Consumer Awakening Mission. Today we are here with the subject how to read judgment and how to understand judgment and ultimately how to quote the judgment in your case. I would like that yesterday I was watching TV program wherein Ayodhya judgment was being discussed. One of the political analysts was pointing out that this judgment will raise many questions from many corners. Okay, it's fine. It's anybody's freedom of expression and it's their own views. That doesn't matter and that doesn't bother anybody in the country. But the amazing thing which was disclosed later on was that he had not read the entire judgment. He had read only 60% of the judgment and was discussing this issue on a national level reputed channel and giving his views without reading the entire judgment. Here I must say this is the mistake sometimes advocates also make, and there is all likelihood that students will also make because they are in the learning process, and I don't expect that they should be expert in all the things right in the beginning. Now let me come to the issue in hands. First thing, writing judgment is an art. But more than that is understanding judgment requires tuning with the law. Let me make it clear how the judgment proceeds. First, judges narrate all the things what petitioner has said and what opposite party or defendant has said in their defense, and thereafter whatever evidence they have led or cross examinations what they have done, according to that they just make first part either in their own language or the same language whatever petitioner has said or defendant has said. It is a discretion of the court in what manner they submit the case. So this is one part, what the parties have said, what the parties have given evidence, what are the supportive documents placed before the court by the petitioner as well as the defendant. This is one part. After this part only, judges proceed further with their own observations. What is their observation? What they have found from the petitioner's points, what they have observed from the defendant's point, and what they agree and what they do not agree, what documents they find genuine and what documents they want to reject, and what they have seen during the cross-examination. Cross-examination part is very, very important because this is the stage where judges observe whether the party is genuinely pressing on their point, whether the parties could really press their point, or whether the defendant could rebut it in proper manner and they had proper evidence and they had very forceful rebuttal in the court, and accordingly they reject some documents, they reject some arguments, and they come to some conclusion. It's like, scrutinizing the things. All the things they scrutinize, and after this final observation, court comes to some conclusion what they actually hold. What is the opinion of the court after hearing the entire set of arguments and everything. So this is the actually procedure and this is the manner how judges write. This is not the final stage, this is the discussion part where the parties are discussing and parties are submitting their case. Sometimes what advocates do, they just pick up this area. That advocate was saying this thing and this advocate was saying this thing, and since court was discussing it and court was placing before it in the judgment, so they feel it is a court's observation which is actually wrong. Correct thing is, after the discussion made by the court and finally coming to the conclusion, which is the operative part, that is the judgment and that is the holding of the court. Another point is, where they make another mistake is, in one landmark judgments, mostly important judgments, they discuss not only one point, they discuss many points. Supposing issue is about real estate. There is one issue that it is a matter of late possession or non-possession. This is one issue. But while discussing this issue, non-possession or late possession, court has to go further with the facts of the circumstances of the case. In the circumstances when petitioner or home buyer has not paid the entire amount to be paid to the developer, so in that case question also comes whether the payment was made within time limit or not. If it is not made, then developer has the right to ask for interest. Now what interest developer asks and what interest home buyer is ready to pay again becomes a dispute. So in this dispute, court has to decide, consumer has to pay and should pay. Again, when the possession should be given or how much time the developer should take to construct the house. If this clause is not there, in the absence of that clause, what court holds? Court has to discuss this issue also. What should be the penalty to the developer for non-possession or late possession, and what should be the rate of interest to be given by the home buyer in case he has failed to pay the amount or the dues within limited time. So these are 2, 3, 4 issues coming in the same judgment. But when you pick up a point, what is your point is more important. If you have to pick up an issue of late possession, non-possession, in that case interest rate or penalty is to be discussed by the court. So you have to go to that judgment where you are picking up that particular issue. It should match. Very important thing is, friends, the circumstances and facts of your case must match with the facts and circumstances of the case and of the judgment which you are picking up for quoting in. So not only one judgment, but what issue also, which issue you want to discuss and on what issue you want to quote the judgment is also to be seen by you carefully and pick up the same quotation which matches and which is required in your case. These are very important things and to be scrutinized very carefully. So for quoting the judgment carefully, you need to understand the judgment. We feel hesitant to accept this fact that we do mistake. But remember, at one point of time, everyone is newcomer. At one point of time, everyone is dealing with the issue for the first time. When you are dealing with the thing for the first time, you are bound to make mistakes. Act doesn't change every day. Language doesn't change every day. It is the court who has to make interpretation from time to time. There is one clause interpreted once in earlier judgment. The same clause now again comes. It elaborates in the next judgment. It makes elaboration. It makes interpretation. It doesn't make law. For this reason, it was decided by many leading papers that journalists should also know law. They should also be given law training or law diploma, or law degree holder should be given preference in journalism. This was what decided for quoting judgments in the paper. So friends, be with us, subscribe our channel so that our future uploads are automatically reaching to you. Thank you very much. Thanks for listening to me with patience. Thanks.